Welcome. My name is Konrad Grotowski and this is program News from Poland, Business and Law, a synthesis for foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors. Today my colleague Łukasz Lasek, advocate, solicitor in England and Wales, not practicing, partner at Wardyński & Partners, will explain legal aspects of fighting cybercrime appearing in the form of business email compromise.
Hi, in this episode we want to share with you our experience in a type of cybercrime called business email compromise. It is a type of cyber-facilitated fraud where fraudsters compromise IT networks, intercept business communications, and by using different manipulation techniques, trick employees into making wire transfers to fraudulent bank accounts. The fraud itself is not a new creature. It is an old trick merely conducted with the use of modern technologies. 5 or 6 years ago, when we started to be instructed in matters of this type, our clients were mostly large corporations with the amounts taken running into millions of euros. The client pattern has changed over time. Now, we less frequently see large corporations, while smaller and medium-sized enterprises are being tricked more often. Our sense is that large corporations have invested in compliance and IT solutions and became more resistant. Smaller firms are not yet there, and many of them were only forced to go online due to the pandemic. Poland is not a jurisdiction the hackers are operating from or where they are targeting their victims. It is most frequently used by fraudsters as a money transit hub. To trick a foreign business, a fraudster needs to divert payments to accounts in credible jurisdictions, not to an account in a jurisdiction that would immediately seem suspicious on its face. Hence, we see that the frauded monies are often diverted to fraudulent accounts opened at Polish banks, and then either forwarded from there to other accounts in more exotic jurisdictions or cashed out by an army of money mules. The example of large corporations is promising. It shows that through awareness-raising programs, proper compliance and IT solutions, any organization can mitigate the risk of business email compromise. Raising awareness and change account protocols do not require substantial investment, and based on our practice, they can be effective. But if you unfortunately happen to fall victim to a business email compromise fraud, time will be of the essence. In many cases in which we have been instructed, our clients were able to recover at least part of the defrauded funds, which were blocked by one of the banks used for the transaction. Banks are under a statutory duty to conduct anti-money laundering monitoring of transactions. If a particular transaction or pattern of client behavior is suspicious, banks may suspend transactions and may block the account for the time necessary for a more thorough review. Of course, human employees are not screening every single transaction. Banks use IT systems to review transactions on an automated basis. As you can imagine, fraudsters try to fly below banks' radar and use accounts in a way that does not trigger internal alerts. So, if you realize that you are a victim of business email compromise fraud, it is critical to report it to the bank where the fraudulent account is held. If the bank was not aware of the fraud, it sure is now and should take action. If the funds are in the account, the bank can block them. If the funds have already been forwarded to another bank, the bank can notify those other banks. If the funds have been cashed out, the bank should preserve available evidence, CCTV recordings, IT logs, and others. We report abuses to banks for our clients. Those reports need to be filed as soon as possible, usually within hours. The report should be submitted through the channel that will give the best chance that it will be reviewed immediately. We usually use emails, hotlines, and online reporting. A report has to contain details and supporting materials showing the bank that it is credible and justifies action. We also advise clients to request their own banks to submit a similar report via bank channels like SWIFT. This adds to the credibility of the reporting. Reporting the abuse to the bank is critical for recovery, but it is not enough. Banks will not disclose any information to us due to bank secrecy laws, so it is essential to also report the fraud to law enforcement. Only the law enforcement authorities can acquire information documents from the bank so that the facts can be pieced together. What has happened to the funds? Is any money blocked? Are there any traces that could lead us to fraudsters, and so on? Shortly after the investigation is opened, we usually are in position to have a clearer picture on the further strategy. If the funds are blocked in the account, we can take actions aimed at getting them back. Currently, the practice for returning stolen funds is rather straightforward. If the funds have been forwarded somewhere else, we may follow the money and request law enforcement authorities to request other banks to produce information and see whether those other banks have blocked the funds. At that point, we usually think about the next strategy. What are the prospects of detecting the fraudsters? Not merely the low-tier money mules, who often have no assets of their own and little ability to compensate for our losses. Can we detect higher-tier players? This is also a time when we start checking whether any third parties have caused or contributed to the loss and might be liable in damages, such as banks or intermediaries. In case of business email compromise frauds, it is also essential to determine to which of the parties the loss should be allocated. Should it be the sender of the money or the party that was expecting the payment? This type of dispute is emerging, and resolution depends on the applicable law and factual circumstances, for example, whose IT system has been hacked. Unfortunately, we see too many of these cases. This type of fraud is only possible if the fraudsters can easily open and operate accounts in credible jurisdictions, through which they can divert large sums of money to places removed from the reach of law enforcement. Governments need to impose stricter rules on opening accounts. Regulators need to enforce these rules better, and courts need to allow for private enforcement of these rules when banks fail to comply. Banks need to adopt better risk assessment and monitoring of accounts in near real time. Banks also need to partner with law enforcement and lawyers to create channels for reporting abuses, much as tech companies do. I'm sure that through public and private measures, the scale of this type of fraud can be effectively reduced.
Thanks, Łukasz. And thank you for watching this episode. See you soon.